Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to talk to you about how to win your Social Security disability hearing. And basically what I want to talk about is what you need to do to make the judge's job easier so that he or she can approve your case. Understand what the judge needs and what the judge does not want to see. And that's how you should focus your preparation. For example, it's really important in disability hearings to have objective medical evidence. That means you need MRI, CT, ultrasound, nerve conduction study test, any type of test that shows a particular medical condition, and it can be documented, as opposed to walking in and saying, I hurt all over, but we don't really know why. Those cases simply don't get approved anymore. You want to have a medical record that shows regular ongoing treatment. Judges do not like to see gaps in medical treatment, so you need to have ongoing treatment. Ideally, you want to have treatment with a specialist. Judges much prefer to see treatment records from specialists as opposed to your family doctor. Years ago, a family doctor's opinion was enough. It is no longer enough. Most of the time, a judge is going to expect to see treatment records from a specialist. The judge will also want to hear from that specialist, as well as your family doctor, about vocational or work activity limitations. Realize that Social Security defines disability in terms of your capacity to perform work. Therefore, if the doctor will make notes or complete a functional capacity evaluation that discusses work capacity limitations, lifting, carrying, sitting, standing, walking, climbing, kneeling, stooping, things like that, that goes a long way, because again, the judge is trying to translate the medical findings into specific work limitations. So if you can get a doctor who will cooperate with your lawyer and complete a functional capacity evaluation, that goes a long way. And if that's from a specialist, that goes an especially long way. Now, there are a few things that a judge is not going to want to see. And again, judges are under a lot of pressure these days because there's some people in Congress who believe that Social Security disability is rife with fraud. I think that's nonsense, but there is a lot of pressure, and judges are not going to approve cases if they see certain things. For example, if they see evidence of drug-seeking behavior, and that would be going from one doctor to the other looking for pain medications. Most pain doctors or doctors who prescribe narcotic pain medications will ask you to sign a contract that says you won't do that. If they catch you doing that, even if you are truly in pain, what will happen is that will get in your record. Most of the time the doctor will fire you, at least both of them will probably fire you, and you'll have a very difficult time explaining to the judge why you engaged in that behavior. By the same token, if you use street drugs or self-medicate with alcohol or buy prescription medications from friends, things like that, that is going to really hurt your case, because again, judges expect to see you completely compliant with your legitimate doctor's medical recommendations. You do not have the right to take it upon yourself to buy pain medications on the street. You don't want to do that. Judges are also going to be looking for what I would call a disconnect between the objective medical evidence and your symptoms. For example, if you claim to have severe knee pain, but the MRI of your knee does not show any significant problem, that's going to be a problem. That's going to be an issue. Now, it very well could be that you have significant knee pain that is idiopathic, that there's no specific cause for. But again, in a disability hearing, that's going to be very hard to convince a judge that that's legitimate. So you want to talk to your doctor about the objective testing, and if you're having pain or symptoms that are inconsistent with the objective testing, you want to discuss with your doctor why that might be, and perhaps look to try to get a different type of diagnosis. You want to avoid an attitude of entitlement at your hearing. That means that judges are they're very sensitive to people who are basically saying, I know I'm disabled, pay me, when they testify something to the effect of when I became disabled or after I became disabled. Being disabled, that's a legal determination. It's not for you to make. And I realize it can be difficult because you may feel that everything's stacked against you, but you always want to go in with the attitude, I'm going to fight this. Anything I can do to go back to work, I'm going to do it. Don't look like you've given up. And judges pick up on this. And I can tell you from doing lots and lots of hearings, when a judge senses that somebody has just given up, they're not trying anymore, it takes a lot more evidence to win because, again, the judge is not going to believe you. On the other hand, if you go into a hearing and you basically show the judge, I'm fighting this, I've tried to work but unsuccessful doing so, I'm trying to walk, I've quit smoking, I've quit drinking, I've done all these things to make myself better, it still is not working, the doctor is saying I'm trying my best but it's not working, then the judge will give you the benefit of the doubt. I had a hearing not too long ago where a client testified he had originally filed and alleged about 10 or 15 different things going on, and by the hearing he said, well, 4 or 5 of those things don't really bother me anymore. That really enhanced his credibility and the judge approved his case. Don't be afraid to do that. Judges want to see, they want the truth. They don't want you to walk in there and say, everything hurts, my pain level's at a 10 all the time. That is not believable. You want to go in there with the idea that you're not entitled to disability, that you're fighting this every step of the way, and that when you have a good day or a good few hours, you're going to try to make the most of it. So those are some tips I can give you regarding how to win your case. And a lot of it's mental, a lot of it's your attitude. And the final thing I would tell you is practice with your lawyer. Do not go to a hearing without having gone through the questions you're likely to get with your attorney. That's what we're here for. So I would tell you that one of the best things you can do, the best use of your time prior to a hearing, is to practice with your lawyer and listen to the feedback and change your approach if you need be. And I realize that sometimes it's late in the game to get objective medical testing, but again, your attitude can go a long way to taking a case that is on the fence and getting it approved. So those are some tips about how to win your disability case. I hope you found it helpful. If you did, please give it a thumbs up on YouTube and Facebook, and let me know if you have any questions. This is Jonathan Ginsberg wishing you the best. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include, how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know, how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.